This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon, gentlemen, and welcome to the Tennessee Court of Appeals. We first of all want to thank you for agreeing to participate in this oral argument via Zoom. We believe this is the best way for us to continue to hear appeals and keep everyone safe. Having said that, though, I want to remind everyone that the same rules, procedures, and protocol that we would be utilizing as if we are in the courtroom is applicable today. All those rules will apply. And of course, part of that is that each side will receive 15 minutes to make its oral argument. If you're the appellant and you've requested rebuttal time from Mr. Hibner before, you'll receive that rebuttal time. I also want to remind everyone that we are streaming live over the internet. So keep that in mind as you make your argument. If we experience any technical difficulties, everybody just remain calm. We'll get them worked out. We don't anticipate any and certainly hope that none occur, but we'll make sure that nothing occurs that prejudices anyone's rights to their argument. Before we get started, I want to take the opportunity to introduce your panel for this afternoon. We have Judge Skip Frierson from Morristown, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started? You may call the case then.
David Cupples et al. Versus Jonathan Allen Holmes et al.
Mr. Holmes, I understand you are pro se. In other words, you're self-represented. Is that correct, sir?
Yes, Your Honor.
Okay. Do you have any questions or anything before you get started? I understand you're not an attorney, and that's fine. There's absolutely no problem with that. I just want to make sure that you don't have any questions before you begin your oral argument.
I have one question, if that's okay.
Sure.
Since both briefs has been filed, a new case has came out. Decide a new case that has came out in between the briefs and now.
A case from the appellate court?
Yes, Your Honor.
Okay, and you want to present that case to us?
I want to cite that, yeah.
Okay, here's what you would need to do is write a letter to the appellate court clerk or do an email to the appellate court clerk, copy Mr. Bowen on that email as well, and cite that case in there so that we can all get a copy of it.
Okay. Yes.
Okay. Does that answer your question?
Yes, I'm still able to verbally cite it. And,
sure.
Okay.
You can talk about it if you'd like. Yes, sir.
Thank you, Your Honor.
Anything else?
That'll be it.
All right, sir. You may. First of all, I need you to introduce yourself to the court because not only is this streaming live, we're also recording it. So we need to know who you are. So
yes,
if you go ahead and introduce yourself, and then you can proceed with your argument.
Okay. Good afternoon. May it please the court. My name is Jonathan Holmes. I'm pro se, and I'm the appellant of this appeal in regards to grandparent visitation regarding Marley Holmes, in which I am the father. I would like to start by thanking you all for hearing my case this afternoon, and I'm here today to ask your honors if the trial court erred in granting grandparent visitation to the appellees. There's a few issues that I want to discuss, but I want to start by explaining some events that transpired in the months of March 24th to April 24th of 2020. In the middle of March, I got information that the mother of my child was using methamphetamine. And then I hired an attorney to file a dependency neglect case in the juvenile court of Decatur County. I received full temporary custodial guardianship, which I was the custodial parent of Miss Marley on March 24th. In between the March 24th and April 24th, April 24th is when the grandparents filed a petition for grandparent visitation. That is exactly 30 days. In between that time, if you can remember, it was a pretty uncertain time, April 2020. And in between that time, I spoke with the grandparents. They did not ask to see the child in any of those 30 days at all. I did tell Marley that she can call the grandparents on her birthday, and she did, and there was no problem. That was on April the 7th. So that would be 30 days in between when I got custodial guardianship of Marley till April 24th, when the grandparents filed for custody. Now, Tennessee Code end of date or Tennessee Code 366306A, it only necessitates a hearing if such grandparent visitation is opposed by the custodial parent or parents. There was no opposition for grandparent visitation on my end, 100% whatsoever. The grandparents did not show evidence of that in the court. The lack of evidence they had showed to the court should have transpired in a dismissal of the case. The evidence that I heard in the case was a text message on Easter of April 2020, when the grandparents said Happy Easter, and I responded to what the grandparents showed in trial court as a negative response. That's the way they fabricated it. The grandmother testified in court. Response was not from a good Happy Easter text. It was directly a response to them filing a lawsuit in the juvenile court for custody of Marley. Why they would file for custody of my child, I have no idea. That's beyond me. And only a few days later, they filed a petition for grandparent visitation. Presenting opposition to grandparent visitation with a single text message, and it was not even an inquiry to visit their grandchild in any setting. That brings me to a case in the Court of Appeals. I believe it's, if I can pronounce it right, Uselton versus Walton. In this case, the grandparents it was stated in this case, the grandparents in this case appeared to be operating under the misguided assumption that because mother had permitted them generous visitation with the child for several years, that they are entitled to continue such level of visitation, and that they are basically entitled to stand in the shoes of their son. This case is different. It's a different scenario as all cases are, but what they're saying is, if something happens, the grandparents can't assume that they're going to get the same amount of visit they had before a life-changing event. In this case, the grandparents saw Marley, I would say, within the mother's time. When something life-changing happens, like a dependency neglect, there's going to be a change in visitation. You can't assume you're going to get the same exact time with the child that you had before that, especially when I am the custodial parent and I have concerns about meth use. I think it's important to know that the mother was living with the grandparents and had a no contact order with the child in the month of April. So that 30-day span of when I got the child until when the grandparents filed their petition, the mother was living in their house. So if I want to put conditions on visitation, I have a constitutional right to do that as an American citizen under the 14th Amendment Constitution. Conditions on visitation does not mean opposition to visitation. That's been agreed on in the Court of Appeals on many cases. And the case that I was speaking with you about earlier, it just came out. It is called in regards of Trinity. And if I can reference that, I'll take that opportunity. So after reading this case and listening to arguments, the findings in the Court of Appeals for this case are pretty similar to what I'm asking. The court, and this was just, I want to remind the court that this was, I believe it was December the 8th when this last year, so just about 4 weeks ago, this case was filed, or the ruling was filed, the reversal. the court stated under Tennessee Code 366306A whether the mother opposed the grandparent visitation prior to the filing of their petition. In Trinity, which was just the grandparent visitation case that was just reversed, the mother created limitations after an altercation with the grandparents. And the Court of Appeals found that limitations does not mean oppositions. The mother has the constitutional right to do that. And I'll also point out in the Trinity petition for visitation, it was just 6 weeks when the and the grandparents. This case we're at today, there was a 30-day span in between when I got full temporary custody of Marley until they filed their petition. And in between that time, the grandparents didn't show any evidence of any offer to see the child. I'm frozen here. I am.
You're okay as far as we're concerned, Mr. Holmes.
Okay. So in the opposition, that's where I'm going to leave that. There is a finding in the trial court that I will state, and I agree with from the judge. He stated, the trial court stated that the father states that he does not oppose grandparent visitation or having visitation with the child. But if I understand him correctly, that should be upon his own terms and decisions rather than the court order. I agree to this, and I believe that the law will as well. This is my constitutional right under the 14th Amendment of the United States Constitution that if I do not oppose visitation, that I should be able to determine when the visitation is and what conditions it is under, especially in a time as in April 2020, when I just filed a dependency neglect and the mother was using methamphetamine, which was located in the grandparents' home, or the building that they have where the mother was staying. It was adjacent. The mother had a no contact order. I have that right as a constitutional, a right as a parent to make those assumptions and conditions. The trial court also found that in the findings was stated that they are concerned that if I deny the visitation and allow Mr. Holmes to make the determination of if and when they see the child, we would probably be back in court. Be back in court just states that the court is concerned the father will not allow visitation in the future. And that's exactly what the Court of Appeals determined in Coleman versus Olson. It can't be used for grandparent visitation when which states in Coleman versus Olson that regardless of the trial court's belief that the father could unlikely facilitate visitation in the future, there is simply no evidence in the record that the father opposed visitation during the relevant period. And what I'm here to ask is there has to be opposition from the parent before the filing. And I did not see any evidence of that or was presented any evidence of that in the trial. And I know there was no opposition because I'm the father. I was there. I know the conditions of April 2020. It was a dependency and neglect. The mother was on meth and I filed that. There was a no contact order. We were under a COVID lockdown. And if I put limitations on visitation, and if I feel that that's necessary for the welfare of my child, just as in Troxel, that I have the constitutional right to do that. And that's my argument. I didn't touch everything in my brief, but I'll certainly try again in my rebuttal.
All right. Thank you, sir. We will now hear from the appellee.
Good afternoon to the court and greetings from the Gibson County Bar. I'm Bill Bowen from the Gibson County Bar, and I represent the appellee grandparents in this case, David and Bridget Cupples. First, I'll try to respond to at least what I perceive to be some of the issues that were raised by Mr. Holmes in his argument. Initially, he seemed to talk about that he is now arguing that he didn't oppose or doesn't oppose the visitation. I'd ask the court to focus in on the actual record in the case. The testimony of the grandparents was that after Mr. Holmes got temporary custody by virtue of a dependency and neglect order, they reached out to him multiple times by text. Many of these times they got no response at all, radio silence from him. The record is full of examples of texts where when Mr. Holmes did respond to the couple's attempt to reach out and inquire about their granddaughter, they were met with nothing short of open hostility. Comments like stay in your lane, don't you understand you're not a parent, worry about your daughter, don't let your ego get in the way. Now, that would be bad enough, but those exchanges culminated with a text that was dated something like April 15th. I believe that's right, April 15th, 2020, which was prior to the filing of the couple's petition for grandparent visitation, by the way, where Mr. Holmes directs the couples not to contact him anymore. Now, to send a text to the grandparents in this case and say, don't contact me, which would make it difficult to arrange grandparent visitation or request it if you've instructed me not to contact you, and then come before this court and argue that you didn't oppose grandparent visitation prior to the filing of the petition is difficult to reconcile. So we would submit that Mr. Holmes' actions in the time period between him getting custody and the filing of the petition are not consistent at all with his claim that he doesn't oppose grandparent visitation. And quite frankly, we think the trial court identified that issue and accordingly. Now, Mr. Holmes is correct that the authorities in our state make clear that there has to be some sort of pre-petition evidence of opposition for the grandparents to rely on. You can't rely exclusively on post-petition. I've just outlined the pre-petition conduct that happened. There's also case law in the state that points out that while I can't rely exclusively to justify my position on post-petition conduct, I can point out post-petition conduct to bolster my argument that the grandparent visitation is contested or opposed. I think that's the Usselton case, has that proposition in it. So if we expand the view even beyond what I've outlined pre-petition and talk about post-petition, from filing date of roughly April 24th, 2020 to July 2020, when the trial judge ordered grandparent visitation while the case was pending. My clients got one visit. That visit was supervised by Mr. Holmes. They had to travel to Middle Tennessee and sit in a park with presents they brought for the child under his supervision. That was the only visit they got until an order went into effect compelling him to allow visitation. So we would suggest that evidence bolsters the fact that we are dealing with opposition from Mr. Holmes, despite his claims to the contrary. Now, Mr. Holmes mentions a number of different times his constitutional right. There's no question at all that as a starting point in cases like these, we do need to recognize that there's a constitutional right of parents to be allowed to be parents, free from intervention from third parties or the government. But there are well-recognized exceptions to that, one of which we're here on today. It's our grandparent visitation statute. And it has passed constitutional muster, and a grandparent or grandparents that can successfully meet all the requirements in that statute, and there are a number of them, it's not an easy statute to navigate, are entitled to court-ordered visits. So while Mr. Holmes is right, he has a starting point of constitutional protection of parental right. That's not the end of the story, and that is not a bulletproof shield he can stand behind. Now, Mr. Holmes also made reference to that he objects to grandparents feeling like they should be able to stand in the shoes or receive the kind of visitation that a biological parent might. If the court will take special note of the requested grandparent visitation schedule in this case that was ultimately approved by the trial judge, it's extremely limited. It is nowhere near the amount of parenting time a parent would receive. I know each member of the panel today is familiar with our parenting plan. over and beyond parenting time, it touches on things like who makes major decisions, tax claiming, who has access to medical records, who has access to the school records, who can contact a medical provider or an educator. The grandparents weren't given any of those kinds of rights. Over and above that, the schedule that was ultimately ordered was painstakingly crafted to fall on time that otherwise would have been the mother's parenting time. Now, the mother testified she understood that this was the plan of the grandparents, not only didn't object, but was in agreement with it playing out that way. So it takes nothing away from Mr. Holmes. The grandparent visitation as ordered takes nothing away from Mr. Holmes, which makes it somewhat peculiar that if he doesn't oppose it, why he objects so strenuously to grandparent visitation that falls on time other than his parenting time under the controlling order out of the juvenile court. Now, Mr. Holmes makes reference to the time period between him getting custody and the filing of the grandparent visitation action. Notably, the statutory framework here, the actual content of the statute, subsection A, which is what we're talking about, contains no binding or set time period that grandparents have to wait before they can file a petition. This doesn't appear to be a mistake by the legislature because in this fairly long statute, multiple times the legislature sets forth a 12-month period for a certain portion of the statute to be satisfied. Certain circumstances have to exist for a 12-month period. So the legislature, it's not foreign to them to introduce mandatory time limits before something can happen. They chose, it appears, not to create an arbitrary time limit where grandparents have to endure their relationship being disrupted before they can seek to take action. I would submit that makes sense. This case is a perfect example of that. These grandparents and this young lady had a relationship that involved the young lady living in the grandparents' home or staying periodically in the grandparents' home for a period of over 2 years. That was leading right up to when Mr. Holmes got a temporary custody order. It would make very little sense for the grandparents to sit on their rights to take action to fulfill an arbitrary time period that the statute doesn't even call for. Every day that passed, this relationship that they seek to protect was being damaged. And so they took action as quickly as they could. And when it became clear to them by virtue of texts like, "Don't contact me," that they were going to get nowhere with Mr. Holmes as far as continuing their visitation and their relationship with the grandchild. So,
Mr. Boyd, let me pose a question to you, and
yes, sir.
It's not necessarily on the subject that you're discussing, but as I understand it, in this case, there were 2 dependency and neglect cases filed, one in Davidson County and one there in Decatur County. Is that correct?
Yes, sir, that is correct. The one in Davidson County was filed, I believe, sometime in 2018. So it happened some time ago. It regrettably came along because the mother in the case, again, was losing her battle with substance abuse. As a product of that order or of that action, the dynamic changed to where mom and dad started alternating week to week from that point going forward. But on mom's weeks, the trial testimony made clear that the youngster was very often visiting with the grandparents on mom's time. The second DNN action came along, Judge Stafford, is the one in Decatur County that Mr. Holmes has alluded to that came down the pike in March of 2020, when regrettably the mother again was stumbling with her struggle with substance abuse. And it was actually my clients that notified Mr. Holmes's family that they had concerns here. And their unfortunate reward for that was being told to not contact him when they wanted to try to set up contact with their granddaughter. Does that answer your question, Judge?
It provides background. My question is this: why does the juvenile court of Decatur County not have jurisdiction of this matter?
I'm glad you brought that up, quite frankly, Judge. It is an issue that, as I've been involved in this case, that I kept my eye on. Now, I would ask you if you have the statute in front of you or nearby. Subsection A of 36-6-306 reads as follows. I'll just read that portion very quickly because I know my time's going to run.
Go ahead.
Any of the following circumstances when presented in the petition for grandparent visitation to the circuit, chancery, general sessions court with domestic relations jurisdiction, other courts with domestic relations jurisdictions, or juvenile court in matters involving children born out of wedlock. This is a very unique set of facts that really didn't have any particular relevance other than on jurisdiction. Mr. Holmes and the mother were married when this child was born. So this child was not born out of wedlock. So subsection A created this world for us where, and we can argue whether or not the legislature ought to take a look at that. But it created this world where there's a juvenile court action that I can't fit my clients into because the juvenile court doesn't have jurisdiction over my action. And so I had to file a sister action, and Judge Aker, or the trial judge took action for us in that action.
Okay. I just was familiar that when juvenile court took jurisdiction of a matter involving a child, it normally continued until such time as certain things occurred. And
you and I thought about this similarly, Judge. On that issue, of course, juvenile court jurisdiction it's a limited court, a court of limited jurisdiction. It's set out in two statutes, 37-1103 and 37-1104, one exclusive jurisdiction, one concurrent jurisdiction. Under the exclusive jurisdiction, where the court has referenced that after a dependency and neglect action, there's some continuing jurisdiction for the juvenile unless some other actions are taking place. That subsection, which is subsection C of the statute, says that is true on issues of custody, which is an important term in this case. This is not a custody case. It's a grandparent visitation case. And that, coupled with the fact that the legislature has created the standalone pair of statutes to deal with grandparent visitation, which starts with the subsection A jurisdictional statement that we've already talked about, I would suggest to you indicates that's why we couldn't find jurisdiction in the juvenile court.
Okay, thank you. I do have one other question. I know your time's running out, but in your responsive pleading, you've asked for an award of attorney's fees. What are you basing that request on?
Your Honor, please, we've only raised two issues and they're linked. So if you'll permit me, I'll sort of address them very quickly, apparently, because I think it'll be a better answer to your question. The first objection we had is that Mr. Holmes's brief was deficient under the requirements under Rule 27. We raised that by motion unsuccessfully. The court invited us to raise it again in our brief if we wanted to, so we've done that. Even after Mr. Holmes was permitted the opportunity to file an amended brief, very quickly, his statement of facts largely were just quoted large portions of the statute that we're dealing with, made it very difficult to identify what precisely he was challenging. Secondly, and maybe even more problematic, the argument section of his brief, I hope the court has noticed, is really nothing more than some random bullet points. It's not arranged in any way that it's clear what issue he's arguing with a particular bullet point. Now, there's case authority in our state that's cited in my brief that talks about that if you don't argue an issue in support, you waive the issue. From that point, that same case law talks about that if your appeal has very little chance of success, then the other party ought to be considered, it ought to be considered to award the other party their fees. They shouldn't have to defend an appeal that had such little chance of success. So we're asking the appeal to be dismissed based on the deficiencies when Mr. Holmes's brief is measured up against the requirements of Rule 27. And because we're making this argument that his argument fails to support his issues, that puts us in the bucket that his appeal did not have a substantial likelihood of success. We shouldn't have had to defend it. And that's the basis, Judge Stafford, of our request for the matter to be remanded to set our fees.
Okay, thank you.
Thank you, Judge. I guess unless there's other questions, looks like I'm out of time. I'll mute myself.
All right.
Thank you.
Mr. Holmes, you now have your rebuttal time, please, sir.
Thank you, Your Honors. I want to touch base on what Mr. Bowen stated about the time period between the filing of the petition and then when I received full temporary custody. He states that there was numerous text messages that was sent to for visitation. In the record, I don't see any exhibits to where the grandparents asked to see their child. The text messages that are in the exhibits are the ones that I have explained earlier, which was in reply to not the Happy Easter text message. It was simply in reply to them filing a motion to intervene in the juvenile dependency and neglect to pursue custody of my child. It was not any response to grandparent visitation. Mr. Bowen also touched about the meth use and the grandparents finding the meth and relaying it to my, he said specifically that he related to my family. I want to point out in the record, I believe it'll show that it took them 12 days to even let anybody know that there was meth found. And they went to my mother. I think it's very important. They didn't even come to me to tell me that the child, there was meth in the child's room. Even testified when on cross-examination that I asked, how many times did you ask to see the child after I gained temporary custody? The mother responded, I don't believe I even asked to see the child. When they did finally ask to see the child in June, their one and only attempt to see Marley, it was granted. I granted every phone call they asked for. I granted every visitation they asked for, which was only one each. The grandparents can't reduce visitation. It has to be the parent that reduces the visitation. The grandparents in this case has simply reduced their own visitation. In this case, it's not my obligation or duty to, as a parent, to force visitation upon the child and the grandparents. The grandparents are to do that job. It's not my duty as a parent. There's no order or anything that states that I must impose the visitation and make that happen without some sort of questionnaire from the grandparents. They simply did not ask. If you don't ask for visitation, they can't expect to get it and then petition for grandparent visitation. It's simply a tool that they have used to say that I did oppose just because I didn't force a visitation on them. Now they did reach out on the Happy Easter and they reached out in June to see the child. I responded, and on the visitation request, I accepted it and I made it happen the very next day. They offered it. We did meet I was not going to let my child go to 2 hours away to Parsons where I had concerns. Okay. And I did put limitations on that. So I did an hour and a half in a park in June. That's a very long time in June. It's very hot and they had a great time. They even responded saying, thank you for letting us see Marley. That's post-petition. My argument is anything post-petition, I believe it could be relevant, but in the Court of Appeals, when these cases, it's particularly reversed because there's no opposition before the filing of the petition, and there was none. There was simply no request filed. If there was, I've done the same thing I did in June. I accepted it and I made it happen. There was simply no request. And I did allow the child's birthday, which was April 7th, smack dab in the middle of the relevant period.
Okay, gentlemen, we certainly appreciate your argument. We appreciate you participating via Zoom. We will take this matter under advisement. And Mr. Holmes, unlike the trial court, we're not going to render a decision today. What we will do is take the matter under advisement, review the record, write an opinion, and you'll receive a copy of that opinion the same time Mr. Bowen does. Okay? Any questions about that?
No, Judge.
Okay. All right, gentlemen. Again, thank you. Mr. Hibner, anything we need to take up before we recess court for today?
No, Your Honor.
All right. We will recess court to the call of the docket tomorrow. Mr. Hibner.
This honorable court is now adjourned for today.
Thank you.
Thank you, judges. Thank you, Mr. Hefner.